Chief Justice, Associate Justices, and may it please the Court. My name is Abigail Ferguson, and I am arguing this case on behalf of the respondent, the State of New York, in this case, Elaine Newman v. State of New York. Your Honors, we are here today because the State of New York has been accused of violating the free exercise rights of pharmacist Elaine Newman, despite her employer, a state-funded correctional facility, providing Ms. Newman with alternative and equal means of employment so that she can live out her beliefs without confliction. This employment, which provided both equal pay and status to her previous position, would have enabled her to practice her beliefs freely while also allowing the facility to function in providing gender-affirming hormone treatment that the state has deemed necessary, but which was impossible for the petitioner to sign off on due to her conflicting beliefs about such treatment and the fact that she was the only person in her position at this facility who had the administrative capability to sign off on such medication. The Northern District of New York has already decided in favor of the State of New York, and the Second Circuit Court of Appeals has affirmed this position. Your Honors, this court should affirm this decision once again for two reasons. First, the State of New York has a compelling interest to require a lead pharmacist to sign off on all required prescriptions deemed necessary by the state, that compelling interest being the enforcement of its 2020 law, which provides gender-affirming hormone medication to inmates. Therefore, the State of New York also has a compelling interest to provide alternative employment to a lead pharmacist who has stated that they cannot perform these necessary duties due to their religious beliefs. This alternative and equal employment was provided, ensuring that the least restrictive means were utilized by the state while achieving the medical results deemed necessary. In saying this, the State of New York has passed the test established by Sherbert v. Verner in 1963, which requires both a compelling interest and least restrictive means possible when considering the implementation of state policies. Second, the State of New York did not violate the Free Exercise Clause because the policy to require a lead pharmacist to fulfill all necessary duties is neutral and generally applicable. The 2020 law indicated that any lead pharmacist at a state correctional facility would need to sign off on each gender-affirming hormone medication prescription individually. This policy is broad enough that it does not advance or hinder any one particular religion or entangle church matters with state. It serves the secular purpose of ensuring the medical safety of inmate patients passing all three qualifications of the Lemon test established in Lemon v. Kurtzman in 1971. This is a policy that Ms. Newman would have been aware of as she completed her studies to become a pharmacist between the years of 2020 and 2023, displayed by her requests for accommodations so that she would not have to fill such prescriptions while she was in